Before we begin, a quick and important disclaimer. The following content is for educational and entertainment purposes only and does not constitute legal advice, professional counseling, or a formal attorney-client relationship. Divorce law is subject to specific state jurisdictions and individual circumstances that vary wildly. You should not act or refrain from acting on the basis of any content included in this video without seeking the appropriate legal or professional advice on the particular facts and circumstances at issue from an attorney licensed in your state. Please conduct your own due diligence before making any major life or financial decisions. Statistics tell us that in the United States, a marriage ends every 42 seconds. But behind those cold, clinical numbers lies a multi-billion-dollar industry that operates on a psychological and sociological tightrope. Imagine walking into a room with a complete stranger, handing them a retainer check that represents months of your hard-earned savings, and then proceeding to tell them the most intimate, shameful, and painful secrets of your private life. Within 60 minutes, this person, your divorce lawyer, becomes the most influential figure in your world. They hold the keys to your financial future, your relationship with your children, and your very identity in the eyes of the state. Yet, sociologically speaking, this dynamic is fundamentally broken from the start. We are looking at a collision between the rawest form of human emotion and the coldest mechanism of American bureaucracy. This is not just a legal battle. It is a profound study in power dynamics, emotional labor, and the commodification of heartbreak. By the end of this deep dive, you will understand the invisible forces that govern the relationship between the advocate and the aggrieved, and why the scorched earth approach is often a sociological byproduct of the system itself, rather than a choice by the individuals involved. This masterclass is designed to pull back the curtain on the American divorce machine. We are going to explore why the client-lawyer relationship is one of the most volatile professional pairings in modern society. For the average American viewer, this isn't just about winning a settlement. It is about surviving a process that is historically designed to be adversarial. We are going to solve the mystery of why your lawyer seems detached when you are crying, why the billable hour changes the way you view your own trauma, and how the sociological concept of the double bind keeps clients trapped in a cycle of litigation. This is the roadmap to understanding the systemic reality of the American legal dissolution, providing you with a lens to see the process for what it actually is: a structured social transition managed by professionals. To understand this dynamic, we must first look at the sociological concept of the professional stranger. In most professional interactions with your doctor, your accountant, or your architect, there is a clear boundary. You provide data, they provide a service. However, the divorce lawyer occupies a unique space in the American landscape. They are expected to be an objective legal technician, an aggressive gladiator, and a de facto therapist all at once. This creates an immediate role strain. In the United States, the legal system is built on an adversarial model. This means that for one side to succeed, the other must, by definition, lose or at least concede. When a client enters this arena, they are often in the midst of a neurological crisis. Research into the sociology of trauma suggests that individuals going through a divorce experience a cognitive decline similar to that of physical grief. When a client sits across from a lawyer, they are looking for validation. They want the lawyer to agree that their spouse is a narcissist, or that they have been wronged. But the lawyer's sociological function is to strip away the emotion and translate the human experience into legally cognizable facts. This is where the first crack in the dynamic appears. The client speaks the language of betrayal. The lawyer speaks the language of the Uniform Marriage and Divorce Act. This translation process is inherently reductive. If you tell your lawyer that your spouse cheated on you and it broke your heart, the lawyer in many no-fault states like California or New York might respond by saying that the infidelity is legally irrelevant to the distribution of assets. To the client, this feels like a second betrayal, this time by the person they are paying to protect them. This leads us to the sociological phenomenon of the retainer barrier. In the US, the high cost of legal representation creates a power imbalance that is unique to the American middle class. Unlike the very wealthy, who view legal fees as a cost of doing business, or the very poor, who may qualify for overstretched legal aid, the average American client is often liquidating their primary safety net to fund their litigation. This creates a high-stakes environment where every email, every 5-minute phone call, and every filing is viewed through the lens of financial survival. Sociologists call this the commodification of crisis. When your trauma is billed in 6-minute increments, the relationship becomes transactional in a way that feels dehumanizing to the client. Consider the data on the billable hour. In major metropolitan areas, hourly rates for experienced family law attorneys can range from $300 to over $1,000. When a client calls their lawyer to vent about a weekend visitation dispute, they may be charged $150 for a 15-minute conversation. Sociologically, this creates a feedback loop of resentment. The client needs the emotional support, but they cannot afford it. The lawyer, meanwhile, must maintain the boundary to ensure the firm's profitability and to protect their own mental health from vicarious trauma. Shutterstock. This brings us to the concept of the lawyer as a gatekeeper. In American society, the legal system is a closed-shop profession. You cannot effectively navigate the division of a 401k, the calculation of guideline child support, or the nuances of a qualified domestic relations order, QDRO, without a licensed intermediary. This gives the lawyer immense social power. They are the translators of a secret language. We see this play out in the information asymmetry model. The lawyer knows the likely outcomes based on historical trends in a specific courthouse or with a specific judge, but they often withhold these potential outcomes early on to manage client expectations. If a lawyer is too blunt about the reality, for example, telling a father he will likely only get every other weekend, the client might fire them and find a lawyer who tells them what they want to hear. This creates a market incentive for aggressive posturing, which sociologists argue actually increases the duration and cost of the conflict. Furthermore, we must examine the aggressor-protector paradox. Many American clients seek out bulldog lawyers. They want someone who will fight for them. Sociologically, this is a manifestation of the client's desire for externalized anger. Because the client feels powerless, they hire an avatar of power. However, the American legal system is designed for settlement. Over 90% of divorce cases in the U.S. settle before a full trial. This means the very bulldog, the client hired to fight, must eventually become the diplomat who convinces them to compromise. This shift from warrior to mediator is often where the client-lawyer relationship collapses. The client feels the lawyer has gone soft or sold them out, failing to realize that the lawyer is navigating the sociological reality of a court system that views trial as a failure of the process. To understand the dynamic today, we also have to look at the historical shift from fault to no-fault divorce. Before the 1970s, you had to prove a sin to get a divorce, adultery, cruelty, or abandonment. The lawyer's job was to prove a moral failing. Today, the lawyer's job is to manage an administrative dissolution. This shift has left a sociological void. Clients still feel the moral weight of the breakup, but the system has no room for it. This moral administrative gap is the space where the modern client-lawyer dynamic often becomes most toxic. We are going to explore how to bridge that gap, how to recognize the systemic pressures on your legal counsel, and how to manage the most expensive relationship of your life without losing your sanity or your savings. This is the sociological reality of the American divorce. To understand the core of this tension, we have to look at the concept of emotional labor through the lens of the American legal professional. In 2026, the American legal landscape has become more automated with AI-driven document review. Yet the human element, the actual interaction between a lawyer and a client, has become more expensive and more fraught with psychological complexity. Imagine a client named Michael. Michael is a project manager in Chicago. He is 44 years old, and he has just discovered that his wife of 15 years is leaving him. Michael enters a high-rise law office, sitting across from a partner who bills $450 per hour. In Michael's mind, he is paying for a champion, a therapist, and a friend. In the lawyer's mind, Michael is a case file with a specific set of risk factors and a finite retainer. This is the sociological friction of the dual agenda. Michael's agenda is emotional justice. The lawyer's agenda is procedural efficiency. Historically, case studies show that when these two agendas collide, the client feels a profound sense of abandonment by their own advocate. We call this the advocacy paradox. The more the lawyer tries to remain objective to provide the best legal strategy, the more the client perceives them as cold or indifferent. In the United States, the adversarial system forces the lawyer to focus on what can be proven in a deposition or a hearing. Michael wants to talk about the time his spouse humiliated him at a Thanksgiving dinner in 2022. The lawyer, looking at the clock, knows that Michigan or Illinois judges will not care about a dinner party dispute when they are trying to divide a pension plan. This leads us into the mechanics of the billable hour as a sociological barrier. In the United States, the billable hour is not just a pricing model. It is a communication filter. Every time Michael picks up the phone to update his lawyer on a minor disagreement regarding the children's soccer schedule, the clock starts. By the end of the month, Michael receives an invoice for $2,000 just for phone calls. This creates a secondary trauma. The client begins to self-censor. They stop telling the lawyer important details because they are afraid of the cost. When the client stops communicating, the lawyer makes decisions based on incomplete information. Historical trends in family law suggest that this lack of transparency often leads to last-minute crises in the courtroom, where a piece of information finally surfaces that should have been discussed months prior. Let us dive deeper into the power dynamics of the intake process. The intake is the first time the client-lawyer relationship is codified. Sociologically, this is a ritual of surrender. The client must hand over their tax returns, their bank statements, their private messages, and their children's medical records. In any other context, this would be a massive violation of privacy. In the legal context, it is the price of entry. A case study from a 2025 legal sociological survey noted that 70% of divorce clients felt a loss of agency during the first 90 days of their case. They felt that the lawyer had hijacked their life. Now, imagine if the lawyer is managing 60 other cases. This is the reality of the American family law practitioner. To the lawyer, Michael is case number 2026-405. To Michael, this is the only thing that matters in his universe. This discrepancy in importance creates a sociological phenomenon known as the urgency gap. Michael sends an email at 10 p.m. on a Friday because he is panicking about a weekend exchange. The lawyer does not respond until Tuesday morning. In those 4 days, Michael's trust in the relationship erodes. He begins to browse social media forums where people tell horror stories about lawyers who take your money and do nothing. This is how the viral cycle of legal distrust begins in America. It is not necessarily that the lawyer is incompetent. It is that the lawyer is operating on a professional timeline while the client is operating on an emotional timeline. We also have to analyze the sociological role of the paralegal and the legal assistant. In the US, these individuals often serve as the emotional shock absorbers for the firm. While Michael thinks he is building a relationship with a lead attorney, he is actually spending 80% of his time talking to a paralegal named Sarah. Sarah is the one who hears the crying, the anger, and the frustration. However, Sarah cannot give legal advice. This creates a bureaucratic layer that complicates the dynamic. The client feels they are playing a game of telephone. Michael tells Sarah a detail about a hidden bank account. Sarah notes it in the file. The lawyer reads the note 3 weeks later during a motion prep. The delay in the transmission of information is where strategic errors occur. Yet the system is designed this way to maintain the firm's profitability. Then there is the influence of the opposing counsel. In the United States, the relationship between your lawyer and your spouse's lawyer is a sociological subculture of its own. They likely see each other in court every week. They might have gone to the same law school. They might even be friends. When Michael sees his lawyer laughing with his spouse's lawyer in the hallway of the courthouse, he feels a sense of conspiracy. He thinks they are colluding against him. In reality, they are engaging in professional courtesy to facilitate a settlement. This perceived betrayal is a major factor in why clients often fire their lawyers mid-case. They do not understand that a lawyer who is on good terms with the opposition can often negotiate a better potential outcome than one who is in a constant state of war. The financial reality of 2026 also introduces the concept of the legal desert and the boutique firm. In many parts of the United States, the cost of living has driven legal fees to a point where the average worker cannot afford a traditional retainer. This has led to the rise of unbundled legal services or limited scope representation. In this dynamic, the client handles the emotional and administrative heavy lifting, and the lawyer only steps in for specific tasks. While this saves money, it shifts the sociological burden of the case back onto the untrained client. This often results in a power struggle where the client tries to act as their own lawyer, leading to procedural mistakes that the lawyer then has to fix at a higher cost. As we look at the interaction between these two parties, we must recognize that the divorce lawyer is also a witness to the shifting definitions of the American family. They see the trends before they hit the mainstream news. They are seeing the rise of nesting arrangements, where the parents move in and out of the house while the children stay put, and the complexities of dividing digital assets like cryptocurrency or intellectual property. The lawyer's ability to adapt to these new social norms dictates the success of the relationship. If the lawyer is using a 2010 mindset for a 2026 family structure, the friction becomes unbearable. But what happens when the money runs out? What happens to the dynamic when the retainer is exhausted and the case is only halfway finished? This is the point of maximum sociological tension. The lawyer has a professional obligation to continue representation to a certain point, but the firm is a business that must pay its own overhead. The transition from a valued client to a liability is a cold, hard reality of the American legal system. It changes the way the lawyer speaks to the client. The emails become shorter. The strategy becomes more focused on ending the case quickly rather than achieving the best long-term result. This brings us to the edge of a much deeper problem. We have talked about the money, the communication, and the roles. But we haven't talked about the most dangerous part of this dynamic. The moment the lawyer stops being an advocate and starts becoming a gatekeeper for the client's own worst impulses. There is a specific psychological phenomenon that occurs when a lawyer realizes their client is lying to them, and it changes the entire trajectory of the legal strategy in a way the client never sees coming. Is your lawyer actually working for you? Or are they working for the judge's approval at your expense? In the next part, we are going to strip away the professional masks and look at the secret communications between lawyers that happen when the clients aren't in the room. We will reveal the hidden scripts used to manipulate client expectations, and the real reason why some cases are intentionally dragged out for years while others are settled in an afternoon. You are about to see the side of the courtroom that never makes it into the movies. To truly understand what happens behind the closed doors of a law firm in 2026, we have to examine the sociological concept of the professional ecosystem. In any American courthouse, there is a shadow hierarchy that the public rarely sees. While you, the client, see a battlefield, the lawyers see a workplace. Imagine a lawyer named Jessica in Austin, Texas. She has been practicing family law for 15 years. When she walks into the courtroom hallway to meet the opposing counsel, she isn't entering a zone of combat. She is entering a break room. This professional intimacy between opposing lawyers is the most misunderstood aspect of the client-lawyer dynamic. Sociologically, this is known as the repeat player effect. In the United States legal system, clients are usually one-time players. They come into the system, get their divorce, and leave. But the lawyers, judges, and clerks are repeat players who must interact with each other every day for decades. If Jessica burns a bridge with an opposing counsel to satisfy a client's aggressive demand today, she might find it impossible to settle a different case with that same lawyer next month. Therefore, the lawyer's primary loyalty often shifts, perhaps subconsciously, toward maintaining their professional reputation within the legal community, rather than strictly adhering to the client's emotional desire for total victory. This creates the first hidden script of the divorce process: the cooling-off manipulation. Have you ever wondered why your lawyer tells you to wait or suggests that a certain motion isn't ripe yet? While there are procedural reasons for this, a sociological study of legal practice reveals that lawyers often use time as a tool to manage client emotions. This is the exhaustion strategy. In 2026, the high cost of living and legal fees means that an angry client in January is often a tired, broke, and compliant client by June. Lawyers know that the passage of time naturally erodes the high-octane anger that fuels litigation. By slowing the pace of the case, the lawyer is effectively performing a type of social engineering, moving the client from a state of emotional volatility to a state where they are more likely to accept a settlement. Let us look at a case study involving a character named David. David is a high-earning software architect in Seattle. He is furious because he believes his spouse has been hiding assets in various digital wallets. He wants Jessica, his lawyer, to hire forensic accountants, issue subpoenas to multiple exchanges, and depose every one of his spouse's business associates. From a legal standpoint, David has every right to pursue this discovery. However, Jessica knows from historical trends in her specific county that the judge assigned to their case hates deep-dive financial discovery for estates under a certain threshold. She also knows that the forensic accountant will cost David $30,000 to potentially find only $5,000 in hidden assets. The dynamic here becomes one of information filtering. Jessica doesn't tell David that the judge is impatient. Instead, she frames the refusal as a strategic choice. She might say that they are keeping their powder dry for the custody hearing. This is a sociological tactic called framing the narrative. The lawyer is managing the client's expectations by feeding them a version of reality that keeps the case moving toward a manageable conclusion. In David's mind, he is being strategic. In Jessica's mind, she is preventing a client from committing financial suicide and protecting her own standing with the judge. Now, consider the secret communications that occur when you are not in the room. In 2026, these communications often happen via encrypted messaging apps or quick huddles in the court cafeteria. These are the moments of professional candor. An opposing lawyer might say to Jessica, "Look, my client is being completely unreasonable about the house, but if you give us a win on the summer vacation schedule, I can talk them down." This is the horse trading phase of American divorce. It is highly effective and leads to most settlements, but it is sociologically jarring for the client. If David knew his lawyer was trading his summer vacation time for a house equity concession without asking him first, the trust would evaporate. Yet, this is how the machine functions. The lawyers negotiate the framework of a deal based on what they know is a potential outcome in court, and then they return to their respective clients to sell the deal as the best possible option. This leads us to the concept of the cooling room effect in the courtroom itself. Imagine if you are at a mandatory mediation session. You are in room A, your spouse is in room B, and the mediator, usually another lawyer or a retired judge, is walking back and forth. This is a controlled sociological environment designed to induce fatigue. These sessions often last 8, 10, or 12 hours. Why? Because the legal system understands that physical and mental exhaustion break down the psychological barriers to compromise. By hour 9, when the coffee is cold and the office lights are buzzing, the client is sociologically primed to sign a document they would have rejected at 9 a.m. Your lawyer knows this. They are trained to endure it. You are not. We also have to discuss the phenomenon of the billable hour as a tool for client control. In many American firms, the billing department is the enforcer. If a client becomes too difficult or demands too much emotional labor, the lawyer might suddenly become very diligent about billing every single minute. This is a subtle sociological signal. Your behavior is costing you money. On the flip side, for a client who is cooperative and follows instructions, a lawyer might overlook small 5-minute tasks. This creates a system of operant conditioning where the client is financially rewarded for being a low-maintenance case and punished for being high-maintenance. But what about the cases that are intentionally dragged out? While most lawyers want to resolve cases to maintain their turnover, there is a dark sociological reality to the firm's overhead. In the United States, a law firm is a business with payroll, rent, and insurance. Historical trends show that in some high-conflict cases, the lawyers on both sides may engage in what is called churn. This isn't necessarily a grand conspiracy to steal money, but rather a mutual agreement to engage in every possible procedural step. They file motions to compel, they set unnecessary depositions, and they argue over the phrasing of a minor order. Each of these actions generates billable hours for both firms. The sociological term for this is institutional inertia. Once the litigation machine starts moving, it is very difficult to stop it because both sides are financially incentivized to keep it running until the retainers are depleted. This brings us to a critical realization. The person you hire to be your voice in the system is also a product of that system. They have more in common with the opposing lawyer and the judge than they do with you. This creates an insider-outsider dynamic that defines the entire American divorce experience. You are the outsider, a temporary guest in a world governed by rules you don't understand and relationships you aren't part of. Is it possible to break this cycle? Can a client ever truly be on equal footing with their advocate? Or are you destined to be a passenger in a vehicle where the driver and the navigator are secretly talking about you in a language you can't speak? In the next part, we are going to look at the psychological warfare of the deposition, the moment where your lawyer and the opposing lawyer finally stop being polite and start the process of stripping away your credibility. We will analyze the specific tactics used to make honest people look like liars and how your own lawyer might be setting you up for a fall just to force a settlement. You need to see how the stage is set before the first question is even asked. The transition from the boardroom to the deposition room is a sociological shift from diplomacy to cold, clinical dissection. In the United States legal system, the deposition is the ultimate truth serum, but it is also a theater of intimidation. For a client, it feels like a personal attack. For the lawyers involved, it is a data mining expedition. Imagine a character named Elena, a school administrator in Ohio. She is sitting in a sterile conference room in 2026. Across from her is the opposing counsel, a court reporter, and her own lawyer, whom she is paying $500 an hour. Elena believes her lawyer is there to protect her, to object to unfair questions, and to act as her shield. However, the sociological reality of the deposition is that your lawyer is often more interested in seeing how you crack under pressure than they are in stopping the pressure from being applied. This is the concept of the stress test. In American family law, a lawyer needs to know exactly how a client will perform in front of a judge. If Elena loses her temper, becomes defensive, or gets caught in a minor contradiction during a deposition, her lawyer is observing this with a detached, analytical eye. They aren't just protecting Elena. They are assessing her value as a witness. If Elena performs poorly, her own lawyer may later use that poor performance to convince her to accept a less-than-ideal settlement. This is the sociological tactic of leverage building within the attorney-client relationship. The lawyer uses the client's own weaknesses, revealed during discovery, to manage the client's expectations for the rest of the case. To understand the mechanics of this, we must look at the psychological warfare inherent in the American discovery process. Discovery is the period where both sides must exchange every document, text message, and bank statement relevant to the marriage. In 2026, this includes a massive influx of digital footprints, location data from smart devices, logs from shared streaming services, and even metadata from smart home appliances. Imagine if an opposing lawyer produces a log showing that Elena was at a specific wine bar on a night she claimed to be home with the children. The question isn't just about the wine bar. It is about the destruction of credibility. Sociologists call this the character assassination ritual. In the adversarial system, if you can prove a person lied about one small thing, you can suggest to the court that they are lying about everything: their income, their parenting, and their history. The lawyer's role in this is complex. During a deposition, the rules of evidence are much broader than they are in a trial. Opposing counsel can ask almost anything that might lead to admissible evidence. Elena's lawyer might sit there in silence while the opposing counsel grills her about her personal spending or her past social media posts. To Elena, this silence feels like a betrayal. Why isn't he stopping them? She thinks. But sociologically, the lawyer is following the script of the repeat player. They know that constant objections are often overruled and can make the client look even more guilty or hiding something. Instead, they let the client hang themselves with their own words, which then gives the lawyer the sociological standing to say to the client later, "You didn't do well today. We need to settle because the judge will not find you a credible witness." Consider the case study of a tech executive in Denver named Marcus. Marcus is involved in a high-stakes divorce where the primary dispute is the valuation of his pre-IPO stock options. During his deposition, the opposing lawyer spends 4 hours asking him about his work travel schedule and his relationship with his executive assistant. They aren't looking for an affair. They are looking for evidence of community waste, the use of marital funds for non-marital purposes. Every meal, every flight, and every hotel stay is scrutinized. The sociological pressure here is designed to induce a state of cognitive overload. Marcus begins to feel like a criminal in his own life. His lawyer, meanwhile, is calculating the billable hours for the transcript review and the subsequent motions that will be filed. This leads us to the sociological concept of the manufactured crisis. In the United States, litigation often moves in a series of peaks and valleys. A quiet month is followed by a sudden flurry of emergency motions and high-stakes hearings. Often, these crises are a byproduct of the legal calendar. For example, if a firm needs to hit their quarterly billing targets, or if a court date is approaching, the intensity of the communication between the client and the lawyer increases. This creates a sense of constant adrenaline for the client, which further erodes their ability to make rational, long-term decisions. Let us dive deeper into the economics of the deposition in 2026. A full-day deposition can cost upward of $10,000 when you factor in the lawyer's time, the court reporter's fee, and the videographer. For the average American, this is a staggering sum, but in the sociological framework of the legal profession, it is a necessary investment in information. However, historical trends suggest that much of the information gathered in a deposition is never actually used in court. It is used as a psychological bludgeon to force a settlement. If you know that I know your deepest secrets, and I have them on video, you are far more likely to agree to my terms on the division of the 401k. The lawyer-client dynamic is also shaped by the third-party influence of experts. In modern American divorce, the lawyer is the conductor of an orchestra that includes forensic accountants, child custody evaluators, and vocational experts. Each of these professionals brings a different sociological perspective to the case. The child custody evaluator, for example, is often a psychologist who uses a different language than the lawyer. They are looking at the best interests of the child, while the lawyer is looking at the legal rights of the parent. When the evaluator's report comes back, and it is unfavorable to the client, the lawyer must once again shift roles. They go from being the client's champion to being the bearer of bad news. They must tell the client that their dream of 50-50 custody is potentially unattainable based on the expert's findings. This is where the internal power struggle within the dynamic reaches its zenith. Does the lawyer fight the expert, or do they convince the client to give up? Fighting an expert is expensive and often futile in the American court system, as judges rely heavily on these neutral third parties. Therefore, the lawyer often chooses the path of least resistance for the firm, which is to persuade the client to accept the expert's recommendation. To the client, this feels like the system is rigged. From a sociological standpoint, it is the system working exactly as intended, to minimize the court's workload by using experts to force consensus. We must also address the impact of the 24-hour digital cycle on this dynamic. In 2026, clients are constantly feeding their lawyers evidence in real time. A text from an ex-spouse at 2 a.m. is forwarded to the lawyer by 2:05 a.m. This constant stream of microtraumas keeps the lawyer-client relationship in a state of perpetual reactivity. The lawyer, overwhelmed by the volume of data, begins to tune out the client's emotional noise, further deepening the client's sense of isolation. The deposition is over, the transcript is filed, and the experts have spoken. You are exhausted, your retainer is empty, and the trial date is looming. But there is a final sociological wall you haven't hit yet: the pre-trial conference. This is the moment when the judge finally enters the dynamic, and everything your lawyer told you about your case might change in a single 5-minute conversation behind the judge's bench. What happens when the judge tells your lawyer, off the record, that they don't like your case? How does your lawyer translate that devastating blow to you without admitting they lost control of the narrative? In the next part, we are going to look at the secret life of judges, and how their personal biases and courtroom culture dictate the fate of American families more than the law ever does. We will explore the hidden signals judges send to lawyers, and the specific ways your lawyer might be preparing you to lose before you even walk through the swinging doors of the courtroom. The courtroom is often portrayed in American media as a sanctuary of logic and law, but sociologically, it is a human institution governed by the specific idiosyncrasies of the person wearing the black robe. In the United States, judges in family court possess a level of discretionary power that is almost unparalleled in any other area of the law. This is the best interests of the child standard, a legal term so broad it allows a judge to project their own sociological biases, upbringing, and personal values onto your family's future. To the client, the judge is a remote, godlike figure. To the lawyer, the judge is a known quantity, a coworker whose moods, pet peeves, and historical rulings are documented in a mental or digital ledger. Imagine a character named Sarah, a graphic designer in Atlanta. She has spent 18 months and $40,000 preparing for her day in court. She believes that when she finally stands before the judge, the truth of her spouse's behavior will be revealed, and she will be vindicated. Her lawyer, a seasoned professional named Robert, knows better. Robert has appeared before this specific judge, Judge Miller, dozens of times. He knows that Judge Miller is a traditionalist who grew up in a household where the mother stayed home, and that he has a historical trend of being skeptical toward high-earning mothers who utilize full-time childcare. This is where the client-lawyer dynamic undergoes its most painful transformation. Robert begins to coach Sarah not on the law, but on the performance of a persona that will appeal to Judge Miller's sociological biases. He tells her what to wear, how to speak, and which parts of her life to emphasize or hide. Sarah feels like she is being asked to lie by omission, but Robert views this as essential strategic positioning. In the American legal system, the judge's perception is the only reality that matters. If the judge has a bias against a certain lifestyle or personality type, the lawyer's job is to sanitize the client to fit the judge's comfort zone. Let us look at the sociological concept of the backchamber signal. In 2026, many of the most important decisions in a divorce case happen during a pre-trial conference in the judge's chambers. This is a private meeting where the lawyers for both sides sit down with the judge, away from the clients and the court reporter. In this setting, the formality of the courtroom drops away. The judge might say something like, "I've read the briefs, and I'm telling you now, Robert, I'm not going to grant a move-away order for your client. If we go to trial, you're going to lose on that issue." This is a critical moment in the lawyer-client dynamic. Robert exits the chambers and has to go back to the hallway to meet Sarah. He cannot tell her that the judge just threatened her case in a private room. Instead, he has to use the sociological tactic of pivoting the narrative. He might say, "Sarah, I've been thinking about the move-away motion. Based on how things are trending, I think we have a higher potential outcome if we trade that for a larger share of the retirement account." Sarah's confused. 10 minutes ago, Robert was ready to fight for the move away. Now he is pushing for a settlement. Sarah feels betrayed, unaware that Robert is actually protecting her from a predetermined loss. This leads us to the sociological study of courtroom culture. Every courthouse in the United States has its own internal social norms. In some jurisdictions, it is expected that lawyers will settle everything except the most egregious cases. In others, trial is a common occurrence. The lawyer's reputation within this culture is their most valuable asset. If a lawyer is seen as someone who drags every small dispute into the courtroom, the judge will eventually penalize their clients with unfavorable rulings, or by ordering them to pay the other side's legal fees. Case studies in legal sociology show that lawyers often sacrifice a client's minor goal to preserve their own credibility with the court for the next case on their docket. Now, imagine if the judge is having a bad day. Sociological research into judicial behavior suggests that judges, like all humans, are susceptible to decision fatigue. A study from the early 2010s famously suggested that judges were more likely to grant favorable rulings after a lunch break than right before it. In 2026, the volume of cases in the American family court system has reached a breaking point. Judges are seeing 20 to 30 families a day. This creates a sociological environment of triage. The judge isn't looking for the perfect solution. They are looking for the fastest way to get the case off their calendar. This triage environment favors the lawyer who can present a clean, easy-to-digest settlement. It punishes the client who wants to tell their story. Sarah wants her hour on the witness stand to explain the nuances of her marriage. The judge wants Sarah to sign a stipulated agreement so they can move on to the next case involving a domestic violence restraining order or a complex business valuation. When the lawyer pressures the client to settle, they are often acting as an agent of the court's administrative needs rather than the client's emotional needs. We also have to consider the role of the courtroom staff, the bailiffs, the clerks, and the court reporters. These individuals are the gatekeepers of the judge's schedule and mood. A lawyer who is rude to a court clerk might find that their motions are placed at the bottom of the pile, or that their hearings are scheduled for 4:30 p.m. on a Friday. Sociologically, the lawyer must maintain a 360-degree web of professional relationships. The client, who sees only their own case, often interprets these friendly interactions as a sign that their lawyer isn't taking the matter seriously. They see Robert laughing with the bailiff and think, "Why is he happy? My life is falling apart." They don't realize that Robert's rapport with that bailiff might be the reason they got an extra 5 minutes of the judge's time. The power dynamic is further complicated by the use of status symbols in the courtroom. In the United States, the physical layout of the courtroom is a sociological map of power. The judge is elevated on a bench. The lawyers are behind tables. The public and the clients are behind a bar or railing. This architecture is designed to induce a sense of awe and submission. When a client like Sarah enters this space, her physiological stress levels spike. She is in a submissive posture, waiting for a stranger to make life-altering decisions about her children. Her lawyer, who is comfortable in this space, occupies a middle tier of power. This comfort gap creates a psychological distance between the lawyer and the client that is almost impossible to bridge. As the trial date approaches, the lawyer begins a process called witness preparation. This is a form of sociological theater. The lawyer tells the client exactly how to react when the opposing counsel asks a provocative question. They are taught to pause, to look at the judge, and to keep their voice level. The goal is to strip the client of their authentic human reactions and replace them with a curated version of a reliable witness. If Sarah cries too much, she might be seen as unstable. If she doesn't cry at all, she might be seen as cold. The lawyer is the director of this performance, and the client is the actor. But what happens when the actor forgets their lines? Or worse, what happens when the judge decides they don't like the director? There is a phenomenon where a judge takes a personal dislike to a specific lawyer, and the client becomes collateral damage in a professional feud that has nothing to do with them. You are standing in the hallway, the judge has just ruled on a temporary motion, and your lawyer looks at you with a face of stone. You've lost the first round. But the real danger isn't the loss itself. It's the fact that your lawyer is already planning the next 3 months of litigation to fix a mistake they made in the first place. In the next part, we are going to look at the hidden economy of legal errors. We will explore what happens when a lawyer misses a deadline, miscalculates a support figure, or fails to file a crucial document, and the sociological ways they cover their tracks while the client continues to pay the bill. You will learn how to spot the signs that your case is being managed for the firm's protection rather than your own. To understand the hidden economy of legal errors, we have to look at the law firm not just as a center for advocacy, but as a high-pressure manufacturing plant where the product is paperwork and the deadline is the conveyor belt. In the United States in 2026, the complexity of family law has increased exponentially with the integration of digital discovery and complex jurisdictional overlaps. This creates a fertile ground for the sociological phenomenon of the professional face-saving ritual. When a lawyer makes a mistake, whether it is a missed filing deadline, a miscalculation in a child support worksheet, or a failure to subpoena a critical witness, the dynamic with the client shifts from a partnership into a defensive posture. Imagine a character named Jason, an engineer in Phoenix, Arizona. Jason's lawyer, a high-volume practitioner named Linda, misses the deadline to file a response to a request for admissions. In the American legal system, failing to respond to these requests can result in the court deeming every allegation made by the opposing side as true by default. This is a catastrophic error that could potentially cost Jason thousands of dollars in asset distribution. However, Linda does not call Jason to apologize. Instead, she engages in the sociological tactic of strategic obfuscation. She files an emergency motion to set aside the default, citing a technical glitch or a clerical error, and then bills Jason for the time spent fixing her own mistake. To Jason, this looks like vigorous litigation. He sees a flurry of new filings and believes his lawyer is fighting a difficult battle against a sneaky opponent. In reality, Linda is performing a repair mission to cover her own tracks. Sociological studies of professional negligence suggest that because of the information asymmetry we discussed earlier, clients are rarely aware when their lawyer is in damage control mode. The billable hour actually incentivizes this lack of transparency. The more a lawyer has to work to fix an error, the more they potentially earn, unless the client is sophisticated enough to audit the invoices. This brings us to the concept of the defensive settlement. This is one of the most guarded secrets in the American legal profession. If a lawyer realizes they have made a mistake that has significantly weakened the client's position, they may suddenly become a much stronger advocate for settlement. They will begin to highlight the risks of going to trial, emphasizing the unpredictability of the judge or the high cost of further litigation. The goal is to close the case before the error is discovered or before it results in a formal court ruling that would create a record for a malpractice claim. In this scenario, the client is being pushed toward a potential outcome, not because it is in their best interest, but because it provides the lawyer with a clean exit from a liability. Let us look at a case study involving the miscalculation of a qualified domestic relations order, or QDRO. In 2026, dividing a 401k or a pension requires surgical precision. Imagine if a lawyer in Florida fails to include a specific clause regarding the survivorship benefits of a retirement account. This mistake might not be discovered for 10 years, but if it is caught during the negotiation phase, the lawyer faces a crisis. Rather than admitting the oversight, the lawyer might convince the client to concede on a different issue, like the equity in the family home, to get the spouse to sign off on a revised retirement order. The client thinks they are compromising for the sake of peace. In reality, they are paying the price for their lawyer's administrative lapse. This leads to the sociological concept of the institutional shield. Within a law firm, there is a culture of protecting the brand. If a junior associate makes an error, the senior partners will often step in to manage the client. This is presented to the client as bringing in more experience to ensure the best result. Sociologically, this is a power move. By adding a more authoritative figure to the room, the firm suppresses the client's inclination to ask difficult questions about the previous mishandling of the file. The client feels flattered that the big guns are now involved, unaware that the big guns are there primarily to limit the firm's exposure to a grievance. Furthermore, we must examine the role of malpractice insurance as a sociological silent partner. In the United States, most family law firms carry significant professional liability insurance. When a mistake happens, the lawyer's first call isn't to the client, it's to their insurance carrier. The carrier often provides a script on how to communicate with the client to avoid admitting fault. This creates a wall of clinical detachment. The lawyer's tone becomes more formal, and they may begin to document every interaction with the client with obsessive detail, looking for ways to shift the blame for the mistake onto the client's failure to provide information or follow instructions. Imagine if your lawyer tells you, "We decided not to call that witness because they might have been unpredictable on the stand." This sounds like a strategic choice. But what if the truth is that the lawyer simply forgot to serve the witness with a subpoena in time? Because the client was not in the room when the subpoenas were being prepared, They have no way of knowing the difference between a tactical decision and a logistical failure. This is the sociological reality of the opaque advocate. The client is forced to rely on the lawyer's version of the truth, even when that truth is curated to protect the lawyer's career. In 2026, the rise of legal tech has added a new layer to this dynamic: the algorithm excuse. Lawyers can now blame errors on software glitches or AI-generated summaries that missed a key detail. This creates a sociological buffer between the lawyer and their professional responsibility. If the tech failed, the lawyer isn't incompetent. They are just a victim of the modern digital landscape. This allows the lawyer to maintain their status as an expert while avoiding the personal accountability that is supposed to be the hallmark of the profession. This economy of errors also affects how lawyers view each other. In the close-knit community of American family law, there is often a professional courtesy regarding mistakes. If Jessica's lawyer sees that the opposing counsel has missed a deadline, they might call them and offer an extension rather than moving for a default. While this is framed as professional civility, it is also a form of mutual insurance. I help you hide your mistake today, and you help me hide mine tomorrow. The only person left out of this pact is the client, who continues to pay for the time spent on these professional courtesies. How do you spot these signs? You look for the sudden shift in strategy. You look for the invoice that has been heavily discounted without explanation. You look for the lawyer who suddenly stops returning calls when a major hearing is approaching. These are the sociological red flags that your case is no longer about your family, but about your lawyer's professional survival. But the cover-up is only one side of the coin. There is a much more pervasive and subtle way that the dynamic is manipulated in the American system, and it involves the very language used in the courtroom. There is a specific vocabulary of power that lawyers use to keep clients in a state of perpetual dependency. In the next part, we are going to dive into the linguistic sociological warfare of the legal system. We will analyze the secret jargon used to keep you confused, and the specific phrases lawyers use to silence your objections during a hearing. We are going to look at the psychological concept of gaslighting in the legal context, where the person you trust to represent you makes you feel like you are losing your mind just to keep you under their control. You will learn the 3 words you should never say to your lawyer if you want to keep the power in your own hands. The sociological study of language in the American legal system reveals that words are not just tools for communication. They are instruments of social stratification. In the year 2026, despite the democratization of information through the internet, the divorce lawyer remains the high priest of a linguistic temple. When a lawyer uses Latin phrases like pro se, pendant lite, or duces tecum, they are doing more than referencing legal concepts. They are signaling to the client that there is a barrier between the layman and the law. This is the concept of linguistic exclusion. By using specialized jargon, the lawyer asserts their intellectual dominance and justifies their high hourly rate. If the process were simple enough for the client to understand in plain English, the sociological necessity of the $500 an hour intermediary would be called into question. Imagine a character named Chloe, a small business owner in Nashville. Chloe is sitting in a conference room, trying to explain that she wants her children to remain in their current school district. Her lawyer, a sharp-dressed professional named Anthony, interrupts her to talk about the statutory factors of the best interest test and the potential for a guardian ad litem appointment. Chloe feels silenced. She isn't talking about statutes. She is talking about her children's friends and teachers. But Anthony has effectively moved the conversation from Chloe's emotional reality to his professional jurisdiction. This is a sociological tactic known as discursive displacement. By reframing the client's narrative into legal categories, the lawyer takes control of the story. This displacement is often accompanied by a psychological phenomenon that sociologists have observed in high-stakes professional relationships: institutional gaslighting. This occurs when a lawyer makes a client doubt their own memory, perceptions, or sanity to align the client with a specific legal strategy. Imagine if Chloe remembers her spouse being verbally abusive during a specific holiday. When she tells Anthony, he might respond by saying, "The court doesn't see that as abuse. They see it as high-conflict communication. If you bring that up, you will look like the aggressor." Over time, Chloe begins to distrust her own judgment. She stops advocating for what she knows to be true because her lawyer has convinced her that her truth is legally a liability. Historical trends in American family law show that this linguistic control is most prevalent during the drafting of the marital settlement agreement. This document is often 30 to 50 pages of dense legalese. When a client asks for a clause to be written in a way they can understand, the lawyer may dismiss the concern by saying, "This is standard boilerplate language." This phrase, standard boilerplate, is a sociological shut-off valve. It tells the client that this part of their life is now under the control of an automated system of precedents, and that their individual preferences are irrelevant. The client signs the document without fully grasping the long-term implications, trusting that the professional knows best. Let us look closer at the 3 words you should never say to your lawyer if you want to maintain your agency. I trust you. While trust is the foundation of any healthy relationship, in the sociological context of the American legal machine, saying "I trust you" is often interpreted as "I am checking out of the decision-making process." It signals to the lawyer that they have a blank check to handle the case according to their own professional or financial interests, rather than the client's specific desires. Case studies show that the most successful potential outcomes occur when a client maintains a healthy level of skepticism and demands clear, plain language explanations for every move the lawyer makes. Another linguistic tool of control is the usage of the royal we. A lawyer might say, "We need to concede on the alimony issue if we want to keep the house." By using the word we, the lawyer creates a false sense of shared destiny. In reality, the lawyer is not the one losing the alimony or keeping the house. The lawyer will get paid regardless of the outcome. This linguistic blurring of identities is designed to make the client feel that the lawyer is in the foxhole with them, which makes it much harder for the client to push back against a strategy they don't like. It is a sociological bonding technique, used to minimize resistance to professional advice. In 2026, we also see the rise of the digital dismissiveness. This occurs when a lawyer uses the volume of digital evidence as a reason to ignore a client's input. Anthony might tell Chloe, "I have 10,000 pages of text messages to go through. I don't have time to discuss your theory on why your spouse is lying." This uses the sheer weight of information as a sociological barrier to genuine communication. The lawyer becomes the filter, deciding which parts of the client's life are worthy of attention and which are white noise. This often leads to a phenomenon called the invisible client, where the case takes on a life of its own in the legal system, while the actual person involved feels like a spectator to their own divorce. Consider the role of the silent witness in the lawyer's office, the clock. In the United States, the constant awareness of the billable hour acts as a linguistic muzzle. The client knows that every question they ask costs them money. This creates a sociological dynamic where the lawyer can dominate the conversation simply by being long-winded. If the lawyer spends 10 minutes of a 15-minute call talking about their own past cases or the judge's personality, the client is less likely to interrupt because they are watching their bank account drain in real time. The lawyer uses their time as a weapon to maintain the hierarchy of the relationship. This linguistic warfare extends into the courtroom during the presentation of evidence. The lawyer uses leading questions to box the client into yes or no answers. This is the ultimate sociological restriction. In a trial, the client is the one with the information, but the lawyer is the one with the microphone. The lawyer directs the flow of information, only allowing the judge to hear the parts of the story that fit the preconstructed legal narrative. If a client tries to provide context or nuance, they are often cut off with a sharp, "Just answer the question, please." This creates a profound sense of alienation. The client is the protagonist of the drama, but they are denied a voice in the final act. They are represented, but they are not heard. This gap between representation and voice is the primary source of the post-divorce resentment that many Americans feel toward the legal system. They don't just feel like they lost money, they feel like they lost their identity to a professional who spoke over them for 18 months. But what happens when the lawyer's linguistic control starts to fail? What happens when a client refuses to be silenced and starts to push back against the standard boilerplate? This leads to a sociological explosion, known as the breakdown of the attorney-client relationship. It is the moment when the mask of professional partnership falls away, and the lawyer's primary goal becomes firing the client while keeping the retainer. In the next part, we are going to look at the anatomy of the fireable offense. We will explore the secret reasons lawyers drop clients right before a trial and the sociological ways they frame the withdrawal to make the client look like the problem. You will see how the system is designed to protect the professional's reputation at the cost of the client's legal standing, and the one question you must ask before you ever sign a retainer to ensure you aren't being set up for an abandonment. The power dynamic is about to shift, and you need to know how to hold your ground. To understand how a professional relationship that began with a handshake and a multi-thousand-dollar check can end in a bitter courtroom withdrawal, we must examine the sociological concept of the difficult client. In the American legal system of 2026, Being labeled a difficult client is the professional equivalent of being blacklisted. This label is rarely about the complexity of the legal issues. Instead, it is a sociological judgment based on the client's refusal to adhere to the power hierarchy we have discussed throughout this series. When a client begins to push back, demand transparency, or question the billable hours, the lawyer begins to build a case for abandonment. This is not called abandonment in the legal world. It is called a motion to withdraw as counsel. Imagine a character named Marcus, a middle manager in Charlotte, North Carolina. Marcus has been in litigation for 14 months. He is frustrated because his lawyer, Brenda, has not secured a hearing date for his custody modification. Marcus starts sending daily emails. He starts saying the firm's managing partner on his complaints. He refuses to replenish his retainer until he sees results. Sociologically, Marcus has broken the unspoken rule of the subservient client. He has transitioned from a source of revenue to a liability for the firm's operational efficiency. Brenda's response is a classic example of the institutional exit strategy. She doesn't just stop working. She begins to create a paper trail. Every time Marcus expresses frustration, Brenda sends a formal, cold letter back, stating that his expectations are unrealistic and that his communication style is impeding her ability to represent him. This is the sociological construction of a breakdown in communication. In most U.S. jurisdictions, a judge will allow a lawyer to withdraw if there is a fundamental breakdown in the attorney-client relationship. By documenting every angry email from Marcus while responding with clinical professionalism, Brenda is setting the stage to fire her client right when he needs her most, often just weeks before a major trial. This leads us to the concept of the midstream hostage situation. Historical trends in family law show that the threat of withdrawal is often used as a tool for client compliance. If Marcus disagrees with a settlement offer that Brenda wants him to take, Brenda might say, "If you don't follow my professional advice, I can no longer effectively represent you, and I will have to ask the court to be relieved." For Marcus, the prospect of finding a new lawyer 3 weeks before trial, catching them up on 14 months of discovery, and paying a new $5,000 retainer is an impossibility. He is sociologically and financially trapped. He signs the settlement not because he agrees with it, but because the threat of being left pro se representing himself is too terrifying. Consider the data on legal withdrawals. In 2026, firms are increasingly using AI to flag high-risk clients based on sentiment analysis of their emails and payment history. If the software determines that a client is likely to file a bar grievance or a malpractice suit, the firm will often initiate a withdrawal early in the case to limit their exposure. This is the commodification of risk management. The client's access to justice is being filtered through a risk assessment algorithm. If you are a high-emotion client in a high-conflict case, you are sociologically predisposed to be dropped by the top-tier firms who want to maintain their win-loss ratios and their insurance premiums. This brings us to the one question you must ask before you ever sign a retainer to ensure you aren't being set up for an abandonment. What is your firm's specific policy on withdrawing from a case when a client disagrees with a strategic recommendation? Most clients ask about fees or experience, but they never ask about the exit clause. If the lawyer is evasive or says it never happens, that is a red flag. You want a lawyer who acknowledges that while the relationship is a partnership, the final decision-making power on settlements rests with the client, not the advocate. We must also look at the sociological impact of the public record. When a lawyer files a motion to withdraw, they must give a reason to the judge. Even if the reason is a vague professional disagreement, the judge and the opposing counsel read between the lines. They assume the client is the problem. They assume the client is hiding something, lying, or being unreasonable. This stains the client's reputation in the eyes of the court for the remainder of the case. Even if Marcus hires a new lawyer, the judge's first impression of him is now filtered through the fact that his previous lawyer didn't want to work with him. This is a sociological penalty that is almost impossible to quantify but is felt in every subsequent ruling. Now, imagine if the withdrawal is financially motivated. In the US, if a client runs out of money, the lawyer is not legally required to work for free in a civil matter. However, the timing of the withdrawal is subject to court approval. A judge might deny a lawyer's request to leave if the trial is too close. This creates a sociological environment of resentment. You now have a lawyer who is being forced by the state to work for a client who isn't paying them. The quality of representation in these scenarios often plummets. The lawyer does the bare minimum to avoid a malpractice claim, but the fire, the creativity, and the aggressive advocacy are gone. The client is represented by a ghost. This dynamic is further complicated by the small world nature of the legal community. If Brenda drops Marcus, she might quietly mention to her colleagues at the local bar association meeting that Marcus is a nightmare. When Marcus calls 3 other firms to take over the case, he finds that no one is available. Sociologically, this is the informal enforcement of professional boundaries. The lawyers protect their own by ensuring that a difficult client is unable to find high-quality representation elsewhere. Marcus is left with 2 choices: settle on the spouse's terms or walk into the courtroom alone. The fear of this outcome is what keeps the American divorce machine running. It is a system of forced cooperation. The client pays the bill and follows the script because the alternative, being an outsider in a system that speaks a different language, is a form of social and financial death. The lawyer, meanwhile, manages the client like a piece of high-pressure machinery, knowing exactly when to vent the steam and when to shut down the system entirely. But there is one final stage of this dynamic that occurs after the final decree is signed and the files are closed. It is the sociological aftermath of the victory or the defeat. In the United States, we have a culture of the winner takes all, but in divorce, everyone loses something. The way your lawyer handles the end of the case, the way they transition you from a client back into a citizen, determines whether you will spend the next 10 years in a cycle of post-decree litigation or whether you will actually be able to move on with your life. What happens when the case is over but the conflict isn't? Why do some lawyers stay involved in their clients' lives for years, fueling a fire that should have been extinguished? In the next part, we are going to look at the sociological phenomenon of the forever case. We will analyze the specific ways the legal system incentivizes perpetual conflict through modification motions and enforcement actions, and the psychological reason why some clients can't let go of their lawyer, even after the marriage is long dead. We are entering the world of the post-divorce industrial complex. The sociological reality of the post-divorce industrial complex is that the final decree is rarely the final act. In the United States, we have constructed a legal framework where the conclusion of a marriage is merely the beginning of a multi-year, or even multi-decade, administrative relationship with the state and its legal agents. This is the phenomenon of the forever case. In 2026, the complexity of modern life, fluctuating gig economy incomes, remote work relocation disputes, and the constant digital monitoring of co-parents has created a system where the attorney-client dynamic becomes a permanent fixture of a person's social identity. Instead of the lawyer being a temporary guide through a crisis, they become a permanent board member of the client's life. Imagine a character named Robert, a middle-aged accountant in suburban Pennsylvania. Robert finalized his divorce in 2024. However, every 6 months, he finds himself back in his lawyer's office. First, it was a dispute over who pays for the children's orthodontic work. Then it was a modification of child support because Robert's firm changed its bonus structure. Now, in 2026, he is litigating over his ex-spouse's plan to move 3 counties away. Sociologically, Robert has entered a state of perpetual litigation. He no longer views his life through the lens of personal autonomy. He views it through the lens of the marital settlement agreement. Every major life decision, a promotion, a new relationship, a vacation, is first filtered through a conversation with his lawyer. This creates a psychological dependency that sociologists call the externalized ego. Because the divorce process was so traumatic and the legal rules so complex, Robert has lost the confidence to make decisions on his own. He fears that any misstep will lead to a contempt of court motion or a loss of custodial time. His lawyer, a professional named Diane, facilitates this dependency. From a sociological perspective, Diane is not just providing a service, she is managing a recurring revenue stream. While Diane might provide excellent legal work, the system itself incentivizes her to keep the door open for future litigation. In the American legal market, a former client who trusts you is far more valuable than a new client you have to hunt for. Historical trends in the U.S. suggest that post-decree motions, modifications, enforcements, and clarifications now make up a significant percentage of the family court docket. This is the machinery of the post-divorce industrial complex. Each motion requires a new retainer, a new round of discovery, and a new series of billable hours. For the client, this is a financial drain. For the legal profession, it is an ecosystem of sustainability. We must analyze the sociological concept of the high-conflict personality as a market driver. In many cases, one or both parties use the legal system as a proxy for the emotional intimacy they lost. Litigation is a way to stay connected to an ex-spouse, and the lawyer becomes the unwitting, or sometimes witting facilitator of this toxic bond. Let us look at a case study of a vocational dispute in 2026. Imagine a woman named Samantha who was awarded alimony based on her spouse's high income in a tech firm. 2 years later, the spouse loses their job due to an industry-wide layoff. The legal battle that ensues is not just about money. It is about the sociological definition of self-sufficiency. Samantha's lawyer hires a vocational expert to prove the spouse is underemployed. The spouse's lawyer hires a counter-expert. They spend $15,000 in legal fees to argue over a $3,000 monthly difference. This is the sunk cost fallacy in action. Both clients are so deep into the dynamic that they cannot see the mathematical absurdity of the fight. They are no longer litigating for a potential outcome. They are litigating for the sake of the process itself. Furthermore, we must address the role of the shadow counselor. In the United States, many clients maintain a relationship with their lawyer because the lawyer is the only person who knows the full, unvarnished truth of their past. Friends and family might get tired of hearing about the divorce after 6 months, but a lawyer is paid to listen. This creates a dangerous sociological blur where the lawyer becomes a surrogate therapist. However, unlike a therapist, a lawyer's toolset is limited to conflict. When a client comes to a lawyer with a grievance, the lawyer's professional instinct is to file a motion. This escalates the social friction rather than resolving the psychological pain. In 2026, we also see the impact of digital enforcement. With the rise of apps like Our Family Wizard or Talking Parents, every communication between ex-spouses is logged and can be exported as a PDF for legal review. This has fundamentally changed the client-lawyer dynamic. Clients now send their lawyers weekly logs of their ex-spouse's perceived slights. The lawyer, in turn, must bill for the time spent reviewing these logs. Sociologically, this turns the lawyer into a digital hall monitor. It keeps the client in a state of hypervigilance, constantly looking for a reason to call their advocate. The peace that is supposed to follow a divorce is replaced by a state of monitored truce. The financial impact of this forever case cannot be overstated. In the U.S., the accumulation of post-divorce legal fees often rivals the cost of the initial litigation. This leads to the sociological phenomenon of the legal debt cycle. Clients take out second mortgages or drain their remaining retirement accounts to fund ongoing litigation over parenting schedules or minor financial adjustments. The lawyer, meanwhile, occupies a position of social authority, often convincing the client that these expenditures are necessary to protect their rights. Case studies show that by the time the children reach the age of majority, some families have spent the equivalent of a college education on legal fees for disputes that could have been resolved through mediation or communication. This brings us to the ultimate sociological irony of the American divorce lawyer. The professional who is hired to help a person transition into a new life often becomes the very anchor that keeps them tied to the old one. The structure of the billable hour, the adversarial nature of the court, and the psychological dependency of the client combine to create a dynamic that resists closure. True success in a divorce case from a sociological standpoint would be a client who never needs to call their lawyer again. Yet, the system is designed to reward the opposite. As we move toward the conclusion of this masterclass, we have to face the most uncomfortable truth of all. We have analyzed the money, the language, the judges, and the forever cases. But what is the long-term sociological cost to the fabric of American society? What happens to a culture where the most intimate human failures are managed by an industry that profits from the extension of conflict? We are going to look at the macro-level impact of the divorce industry on the American family, and the potential for a new model of dissolution that strips away the power of the professional stranger. But before we get there, we have to look at the final, most explosive part of the dynamic. What happens when the client decides to fight the lawyer? In the final part, we will explore the world of bar grievances, fee arbitrations, and the secret ways the legal community protects its own when a client finally realizes they have been treated as a case file rather than a human being. We will reveal the ultimate leverage a client holds and why most people are too afraid to use it. The final curtain is about to be drawn on the American divorce machine. The final phase of the client-lawyer dynamic is often the most hushed and guarded territory in the American legal landscape. It is the moment when the client ceases to be a passive consumer of legal services and becomes a challenger to the professional authority they once funded. In 2026, as legal fees in the United States continue to climb and the complexity of cases increases, the sociological tension between the advocate's bill and the client's perceived value has reached a boiling point. We are talking about the world of fee disputes, bar grievances, and the institutionalized defense mechanisms that the legal profession uses to protect its own reputation. When the client-lawyer relationship breaks down completely, it reveals the rawest form of the power dynamic we have explored throughout this series. Imagine a character named Thomas, a civil engineer in New Jersey. Thomas has just received his final bill after an 18-month divorce. He spent $120,000 in legal fees. When he looks at the itemized invoice, he sees charges that feel like sociological theft. $50 for a 5-minute email, $3,000 for a research memo he never saw, and $10,000 for a trial preparation that resulted in a settlement 15 minutes before the hearing started. Thomas feels a sense of moral outrage. He believes he has been overcharged. But when he voices this to his lawyer, the tone of the relationship instantly shifts from professional partnership to defensive hostility. The lawyer, a veteran named William, immediately references the retainer agreement Thomas signed nearly 2 years ago. This document is the sociological anchor of the lawyer's power. It contains clauses that Thomas likely glossed over in his initial state of emotional crisis, clauses regarding mandatory arbitration, and the lawyer's right to put a lien on Thomas's property if the fees aren't paid. In the United States, the legal profession has perfected the art of self-protection through contract. Thomas is now facing a new kind of litigation, a battle against his own representative. Historical trends in the U.S. show that fee arbitrations are rarely a win for the client. The panels that hear these disputes are often comprised of other lawyers. Sociologically, this is known as professional solidarity. While the panel members aim for fairness, they are also operating within the same billable hour system. They understand the overhead of running a firm. They are predisposed to view the lawyer's time as a sacred commodity. Case studies suggest that unless there is a glaring mathematical error or a violation of ethics, the client might only see a 10 to 15% reduction in the bill, while the lawyer keeps the rest. This is the sociological wall that most clients hit when they try to challenge the cost of their divorce. Now, consider the ultimate leverage a client holds, the formal bar grievance. In every state from California to Florida, there is a disciplinary board that oversees the ethical conduct of lawyers. This is the one thing that truly terrifies a practitioner. A bar grievance is not about money. It is about the lawyer's license to practice. If Thomas files a grievance alleging that William neglected his case, lied to him, or had a conflict of interest, the state bar must investigate. Sociologically, this flips the script. The lawyer is now the one being judged by an authoritative body. However, there is a reason most people are too afraid to use this leverage. The process is designed to be intimidating. The lawyer is a professional at defense. When a grievance is filed, the lawyer will respond with a multi-page brief, supported by years of notes and emails, often painting the client as unstable or uncooperative. This is the sociological counterattack. The lawyer uses the very secrets the client shared in confidence to discredit the client's complaint. In 2026, the digital trail makes this even easier. Every frustrated text message Thomas sent becomes an exhibit in the lawyer's defense. The client realizes that by attacking the lawyer, they are opening themselves up to a secondary violation of their privacy. We must also examine the sociological concept of the professional blacklist. In smaller legal communities, a client who sues their lawyer or files a bar grievance becomes persona non grata. If Thomas ever needs legal help again, for a real estate closing, a will, or a business dispute, he may find that no one will take his case. The word spreads among the local bar association. He is labeled as a litigious client. This is the informal social control that keeps the American divorce machine running smoothly. It ensures that the majority of clients, even the dissatisfied ones, walk away quietly rather than challenging the system. But what does this mean for the future of the American family? Sociologically, the current dynamic creates a legacy of cynicism. When people feel that the legal system is a game played by insiders for the benefit of insiders, they lose faith in the rule of law. We see this in the rising trend of pro-se litigation in 2026, where Americans are choosing to represent themselves, not because they are confident, but because they simply cannot trust the professional stranger dynamic anymore. This shift is a direct response to the sociological friction we have analyzed. Imagine if there was a different model. Imagine if the American divorce were treated not as an adversarial legal battle, but as a sociological transition managed by mediators and financial neutrals who do not profit from the extension of conflict. This model exists in some parts of the world, but in the United States, the multi-billion-dollar legal lobby ensures that the current machine remains intact. The power imbalance is baked into the very fabric of our society. As we close this deep dive, we have to recognize that the client-lawyer dynamic is a microcosm of the American experience. A collision of high-stakes emotion, extreme financial pressure, and a bureaucratic system that values process over people. To survive it, a person must enter the room with their eyes open. They must understand that the advocate is also a businessman, that the judge is a human with biases, and that the language of the law is a tool of control. This journey through the sociology of divorce has revealed that the real battle isn't with your spouse. It is with the system you are forced to use to leave them. By understanding these invisible forces, you move from being a victim of the process to being an informed navigator of it. The American divorce machine is powerful, but it relies on your ignorance to function. Now that you have the roadmap, the question is, how will you use this knowledge when the stakes are your children, your money, and your future? This masterclass has covered the psychological, financial, and institutional layers of the industry. But there is one final, hidden dimension we haven't touched. It is the role of the secret influencers, the lobbyists and the legislative groups that write the very laws your lawyer uses against you. While we have focused on the individuals in the room, the true architects of your divorce are miles away in state capitals, ensuring the machine never stops turning. In our next series, we are going to expose the legislative puppet masters of the family court system. We will look at how special interest groups influence custody laws to create more billable hours, and the dark money behind the maintenance of the adversarial system. You think you know how the law is made? You haven't seen the half of it. The deep dive continues in the halls of power.